Hello, everybody, and welcome to this month's Construction Contract Administration Practice Community. I want to hand it off to Jim to get started with today's topic. So, Jim, over to you.
Thank you, Matthew, and welcome everyone to part 2 in a 12-part series of an introduction to construction contract administration. For those that may not know, we are following along with the Construction Contract Administration Practice Guide. That is the book CSI has for use in establishing and organizing and operating within the construction contract administration phase of your projects. The second thing I would like to just say before we start is please in that survey list any ideas that you have for further discussion, whether it be general ideas of other things for us to undertake and talk about, or suggestions for a deeper dive into any one particular discussion or idea. It certainly is something we want to see from you so that we take this discussion in the directions that you would like to see. I apologize for my cohort. Doug Freeman is not able to join us today, but his name is listed here, and he's been part of this series production from the beginning. So, Matthew, let's go ahead and get started. And what we're going to talk about with the next slide is roles and responsibilities, which goes along with Chapter 2 of the Practice Guide. So let's take a look at the next slide. We're going to talk about construction sites and roles and responsibilities. Certainly, the three of us, the architect or engineer, the owner, and the contractor, need to understand well our roles and responsibilities. We're going to touch on these as well as in the end of the discussion today, a conversation about expectations. But to begin, we're going to talk about roles and responsibilities, and certainly the contract documents identify those, and they're very explicit about what we are to do, and also, importantly, what we are not to do. But as I said, we're also going to touch on expectations. So let's take a look at the next slide. We certainly have defined between the owner and the contractor, who are the parties to the construction contract, what their roles are and the responsibilities of each. And then as the architect or engineer, we, with our contract directly with the owner, have contractual duties that describe our roles and responsibilities, and we're going to touch on those. And then we also have duties and limitations of authority within those contractual agreements as well. And they are further expanded typically in our contracts within the conditions of the contract, either the general conditions or supplementary general conditions. So let's go to the next slide. The requirement for our service to the owner as an architect or engineer, or the contractor service to the owner in their agreement, contain a series of coordination agreements, and they are the conditions of the contract that establish our responsibilities. However, there may be those of you who use non-standard documents. The conversation for today will talk about standardized documents like AIA or EJCDC use, for example. But it is important to understand that in providing construction contract administration, the agreements between you and your client are critical to use and critical to have in your possession and follow. I often say you may work in a firm where it's not appropriate for you to have certain information. Maybe that's hard to get out of firm management. It certainly is something that could be redacted, where there's perhaps financial information that they don't want to get outside the firm. I would recommend that you always ask for these agreements with information stricken that the owner of the firm or owners of the firm is not comfortable with sharing or distributing to the staff there, so that you are able to see what it is that your role or your responsibility is as defined in the contract. What are the expectations that you need to follow, that you need to serve for your client? And certainly, reviewing your documents is an important first step. So let's take a look at the next slide, and we're going to move on to the construction site here. Matthew, go right to the next one, and we're going to jump into the architect and engineer's role. So before we do, let me pause for a second and see, Matthew, if there are any questions or statements from anyone before we jump in.
No, at this time we are still quiet.
Okay, great. Well, one of our primary responsibilities as the architect or engineer is to represent the owner, to keep them informed of progress on the job. We certainly are authorized to act on their behalf, as our contract documents may stipulate. And we are, as I like to define it, a conduit, a path of information between the owner and the contractor that would flow through the architect or engineer in order that we may assure communication is occurring as it should, and that we are kept aware and in the loop with things that are going on. We're also there to observe the project. These are visits that, again, should be spelled out in your contractual agreement, and they are at appropriate intervals. You're not expected to do exhaustive inspections, but observations of the project, where you are becoming generally familiar with the progress and the quality of the work, and whether in the end of the job you can determine that the work is in conformance with the contract documents. You're also, as you're observing the project, endeavoring to guard the owner against defects and deficiencies in the work. So you're out confirming that it is within conformance to the contract documents. And during this phase, you certainly have the authority to reject work that is not in conformance with the documents. You're looking at test reports, etc., to be able to establish whether or not, for example, independent parties think that the documents are being followed. And then you are also certifying and or recommending. For example, in North Carolina, you certify applications for payment. In other places and in other contracts, for example, EJCDC documents would say that you recommend application for payment. So this is one of the roles that we have on the project. And in the end, we are issuing certificates of substantial completion or final completion and certifying that the project is ready to be paid for. So as we perform our duties on the site. We're also interpreting the contract documents, trying to decide and resolve or answer questions that the contractor may have. We're looking at their performance on the job and trying to provide interpretations that are consistent with the contract documents to maybe clarify what was reasonably inferred in the documents, or that they may not fully understand. And then we are also making decisions regarding aesthetics as far as a final work in place decision. We're also reviewing and deciding claims should they occur, either by the owner or by the contractor. And those would initially come to us. Documents contain often a reference to the final decision maker in a project, and most often, in my experience, that is established by the architect or engineer as the architect. And in this role, then we issue written decisions on claims, and we're also involved, should it come to that, in mediation, arbitration, or litigation, if that is a part of a project. Let me take a pause right there, Matthew, and see if there's anything so far as we're going through from anyone.
There's just two comments that have come in. One from Dean saying, note, be clear when to observe and when to inspect, two different levels of exposure. And also Bruce indicates, excuse me, during construction, you do not represent the owner. Your role is to protect the terms of the contract.
Well, those are good comments, and I'll touch on observations and inspections. Absolutely, there are, in fact, two inspections, a substantial completion inspection and a final inspection. And the other trips and opportunities to the site are for observation of work. In the AIA contracts, I'd be interested to know the comment about representing the owner, because at least the ones I'm familiar with working with, it actually uses that language. So I'd love to get a follow-up comment from whoever that was and see what their reference point is as far as a document there. And I'll go on and talk about modifications to the contract, and then we'll stop again here at the bottom of this list. So also, one of our roles is in evaluating any kind of substitutions or deviations from the contract documents. We all understand probably the word change orders or change order or field order. These are documents that we use to modify the contract documents should those items become necessary or a part of the contract. We use things called change directives where we may make minor changes to a project. And of course, we'll talk about those as we go through this series in greater detail in other chapters. And then we also have an expectation to make minor changes in the work, to issue supplementary instructions as those might be necessary to continue to move the work forward. In the next role, we are reviewing submittals. We're taking action on construction submittals that the contractor sends us. Perhaps these are pre-construction items. Perhaps they are schedules of information, schedules of values. Perhaps they're subcontractor lists or product lists. There's a long discussion about submittals that we'll have in the future. But that's one of the roles that we review and take action on those. And then as we get closer to the end of the job, we're looking at things like warranties, certificates, affidavits, record documents, etc. And we touch on here inspect versus observe, so that we are doing an inspection for substantial completion and for final completion. And then, in that same regard, if the owner is attempting to perhaps occupy a portion of a project, where we might look at that so that they could move into a piece of the project early. Matthew, let's take a look at the next slide, because these two at the bottom are a little bit better described on the next slide. And this is a figure from the Project Resource Manual, which existed, the CSI Project Resource Manual, before the Practice Guide. As important as it is to understand our roles and responsibilities, it too is just as important to understand the limitations of those roles and responsibilities. This is a diagram of two different documents, an AIA document and an EJCDC document, that define some of the things that we are specifically not authorized to do. And so we want to always understand the limitations of our service while we understand the roles and responsibilities of our service that we are expected to provide, such that we don't cross the line and take on more authority or more responsibility than we are given within the contract documents. So let me pause there, Matthew, and see if there are any follow-ups or any other new questions.
Sure. We had a couple more comments. I'm going to read here. Just they would like to remind students that submittals are not to be used for substitutions. Is one thing that popped up here. Additionally, we have comments that came in for suggestion that we are representing the owner by fairly administering the provisions of the contract, and sometimes we forget that it is possible to be fair and truthful even when we are playing on one of the teams.
I love that. Let me interrupt if there's anything else. That's absolutely right. And we are charged to be fair and impartial, truthful, honest, straightforward, by the book, by the contract documents. But we are to be fair and impartial, and it's absolutely true that, and some of those most difficult days, being a construction administrator, to side with someone who, or you come out on the side of a decision that is against your client or your owner, and that is not an easy position to be in. But if you are factual and if you follow the contract documents, you use your own documents and specifications and contracts, that is an easy path to find. I think it's an easy path to stay on. I like to think that being a construction administrator is not any different than living your life. And if you are fair and impartial and not judgmental, those are good habits to have as a construction administrator. So you're right. Even though it may not be the team that you find yourself on, the truth is that this is typically a 3-person or a 3-party team. I say often, most of my experience is design, bid, build. So I use that position for most of these conversations. But you're right. Being a representative of the owner, you are to be fair and impartial. Any others, Matthew?
We had one question came in. I'll let you decide if you want to answer it now or if you want to address it when we get to the other aspects of the roles. But the question is, who reviews and approves substitutions?
Well, first of all, that word "approve" is a risky word, but I embrace it. I've been through enough situations to know that often we try to use a lot of language to not say approve, when in fact that's what we're doing. At least a lot of the legal systems that I have been exposed to would say, yes, you did approve it. You might not have used the word, but you did. So substitutions, in my experience, come first to the architect or engineer. It's sort of a lengthy answer, and I start a lot of these with saying the answer is it depends. It depends on the delivery method for the project. It depends on the contract for construction. It depends on your agreement with your client, and it depends on, I'm sure, other things that I'm not thinking of. But substitutions should come before a project is bid so that everyone has equal opportunity to consider that particular product. Often that's not the case. Often substitutions come after the bid. And in my experience, it's an opportunity then to have a discussion with your client about whether or not that is an acceptable substitution. if it is actually an equal product or not. But you have to be careful because it can lead to complications with the bid itself if it's a major substitution and others didn't have an opportunity to bid it. So that's why I say it depends. Again, my experience has been that with the architect and engineer, in connection with the owner and whomever they may have on their staff, whether they have a facility division or construction managers, people that are a part of their organization that want to have input, there's a review process that can lead to that request being rejected. It can lead to acceptance. It can lead to acceptance with some contract adjustment. So all those things have to be considered when there's a substitution request presented by the contractor. Typically, though, it comes to the architect engineer who reviews it in conjunction with their client. Any others, Matthew?
That is it for now.
Okay. Well, let's take a look at the next slide, and we're going to move right to the site. And if we take a look at the next one, look at the owner's roles and responsibilities. So much shorter list, just taking a quick look, but maybe not necessarily so. So, Matthew, I apologize. I'm not sure what the next slide is, but I think the next one is the one we want to have up. There you go. Yes. To have this part of the discussion. So, what is the owner's role here? Well, first of all, there's a lot of information to provide. So our three major headings: information to provide, cost to cover, and rights that the owner retains throughout the construction phase of the project. So we'll talk about information. First of all, there's a great deal of information that the owner needs to furnish to the contractor so that the contractor is sure that they are liquid, that they have the financial resources to be able to undertake and pay for the project, and that there is legal information about who the owner is, so that should there be any claims, that liens or claims can be filed, mechanics liens, etc., so that there is that information about the client, about the owner, that is made available to the contractor. And the contractor also needs to understand and be proven that the owner actually does own the site, and that the site description is a legal description of where the project is being undertaken, and that is in the owner's possession. And all of this information has got to be provided to the contractor in a reasonable amount of time, being prompt to particularly feed information to the job so that the momentum that job builds can continue, perhaps through the bidding process into the construction phase, that this information is turned over so that in a prompt format, so that work can begin straight away. And of course, there are a lot of documents that the contractor will need to have to execute the work. More and more often, maybe these are digital instead of hard copies, but copies of the drawings and the project manuals, as well as any other information that the contractor needs to execute the work, are important for the owner to provide. So we've got a wealth of information that needs to be transferred from the owner to the contractor at the beginning or before the beginning of construction. And then there are some things that the owner has typically as costs that they incur and that they undertake to provide. So approvals, easements, assessments, any charges that may be applied to the project for the construction itself, use or occupancy kind of charges. These are not building permit charges or any other fees that are required for the execution of the work. but are further charges as defined there under owner's costs. Now, sometimes those can be shifted in the construction contract, but typically this is what we see in a design, bid, build kind of market. And then there's property insurance that the owner incurs the cost of to maintain throughout the duration of the project. And then there are owner's rights that are important for us to know and recognize and to assist them in maintaining or managing. One that's very important that I have found historically misunderstood by many is issuing a stop work order. If the contractor is failing to perform or comply with the contract documents, or for some other reason the work needs to be stopped on the project. Those two words, stop work, are some of the most important that we need to understand as construction contract administrators. Now, the owner may look to us for recommendations and involve us in a discussion about stopping the work, but that is not something that we do. It is something that comes from the owner to the contractor, and it's one of their rights. They also have the right to carry out work if the contractor isn't performing in compliance with the contract documents, whether that means bringing in their own forces to perform some part of the construction, or whether that is awarding subsequent construction contracts to other contractors to have that work performed. They have the right to do so. These are not things that are simply undertaken, and they demand a great deal of thought and contemplation before they're ever done, but the owner has that right. They also have the right to clean up the site if the contractor is not doing so. And these things can occur and do occur at the contractor's expense, so that at some point there is an adjustment in the contract price to reimburse the owner for these costs. The owner has the right to partially occupy a portion of the work if that suits their needs and makes their existing operations or newly started operations to occur in a time frame that they need. Typically, these things are discussed prior to construction. Projects may be phased. There's usually an understanding early in the project that this kind of thing is being contemplated, that a portion of the work may be occupied. But sometimes it occurs over the life of the job that things have gotten behind. Areas of the project are occupiable and certainly would make things easier for the owner to ramp up their operation if they took partial occupancy, and they have that right if they choose to. They can also terminate the contract or suspend the work for cause or convenience should they find themselves in need to do so. And they can also terminate the contract for convenience, which is a right that they have. So those are a quick review of the owner's role in the construction phase. Matthew, are there any questions at this point before we move to the contractor?
Yeah, we have a few popping up, so I'm just going to pull them all over here on the side of my screen so I can get to them all. So we have one that came in with actually no name, so I'm not sure who asked it, but it says contract administrator, but not contract administrator, in quotes. It matters. Sorry, I had to read it to make sure I was understanding the statement here properly. Let's see here, the screen is all going weird. There's a suggestion here from Ron saying, I believe it is extremely important to encourage us all to stop using the term construction administrator in quotes because we are construction contract administrators. There's a difference. So I think that was the rest of that line that was being a little goofy. Additionally, from Dean, we have I sometimes find owners do not want to pay for surveys or perfection of title using existing information, and this can lead to a disaster. So it sounds like Dean may have had a couple of war stories to share with us here.
Hang on. Let me interrupt you for a second and say two things. One is that first with the survey statement. This is a horrendous movement within the state of North Carolina. Anyway, we are seeing the change, and actually we're seeing AIA documents being created for that survey service to begin to come through the architect and engineer for the owner, and is something that we have tried desperately as an organization not to have happen for the very reasons that you name there, and that image. Before we went to this owner information of the highway is one of my most horrendous stories that relate to survey. You're absolutely right. That's a scary undertaking. And I want to go back to the construction administrator. I could not agree more. It is so difficult to get people to say CCA instead of CA, and I don't know. It's almost like getting people to say carbon copy instead of Xerox. You know, you're absolutely right. We are not construction administrators. We are construction contract administrators, and CSI has always done a good job of designating it that way. It's a change in the language out in the world that we need more people stomping up and down about. That's for sure. Sorry, Matthew, go ahead.
All right, additional comments coming in here from Mike. In this day of electronic distribution of drawings and project manuals, we have shifted the cost of printing to the contractor. What does provide free of charge really mean anymore?
Well, it's an interesting thought. We within North Carolina, for example, the agencies that manage construction, for example, we have a state construction office, and they define that for you. They tell you, and they use a printed copy guideline. Here's how many copies of drawings, and here's what the contractor should have, and you should print them, and this is what you'll be reimbursed for. So it's a good question. What does free of charge mean?
Additional comments we have, or I guess questions. One from Kevin here. Do the owners have a right to have a standards guide?
That's a good question. I don't know what exactly you mean by a standards guide. Are you referring to the way that we perform our service, or what their standards are? I know, for example, in the public education system, depending on the size of the county here in our state, many of them do have a standards guide, and their contracts are completely unique to that county, but are all the same for any schoolwork that they do. And they've got standards of roles and responsibilities for us. For example, one of them is that they like to take out the site observations will occur as necessary for the project, but no less than once per week. And they modify that to be that they'll occur as often as necessary. So they've created their own standard. I don't know if I'm answering the question there or not.
Looks like here we have, so follow back for that related to this. Most of the major hotel chains, for example, have a comprehensive standards guide that outlines not only the roles and responsibilities of many of the materials used on the project, and additionally an owner standards guide must be incorporated into the contract docs, comes in from Ron. So I'm not sure if that adds to that conversation as well.
Right, that makes sense. Yep, I could see that.
All right, and then we also have an additional question comment here from Don saying, please be sure to distinguish the time period when an owner can partially occupy the building while construction is still continuing.
Right. It would be absolutely coordinated with the authority having jurisdiction, for example, in the area to say yes or no, this is safe, this is within our expectations of an area being complete, certain ramifications of systems and the ability to have safe access and exit way and that sort of thing, so that that area could be finally reviewed, inspected, punched, and turned over and have independent systems. So you're right in the point that it can be a very complex issue to work out.
Okay, that pretty much gets us all caught up at this point.
Okay, well let's move on to what the contractor's role is, and we'll go right through the finally finished dyed concrete floor there to the image of what's the contractor's role and responsibility. And first, and easily understood, they are to review and understand the contract documents so that they know exactly what they're doing, and they are to perform in accordance with those documents so they have a thorough understanding of what the work is and what is to be put in place at the end of the project. And they are to supervise that work as it goes into place. If there is work occurring, then the contractor is to be represented and aware of the work occurring and observing that work and managing that work. If there are any errors or omissions, that they note those during their review and forward any kind of a conflict to the architect or engineer for review and for coordination and correction or supplemental information that they may need an interpretation to clarify that. And they are responsible for all the means and methods to implement the work, solely responsible for the sequences, the techniques, the procedures, and should they omit anything during that process, then they are responsible for those omissions, whether it's by the contract, by the contractor, by their employees, or by subcontractors that they may oversee. And they have to inspect the work and determine that it's ready for subsequent work to move forward. So as part of their responsibility and means and methods, they have to be sure that Part A is done before they begin to do Part B. They also are responsible for safety on the site related to all the work that's underway on the site. They are completely responsible for job site safety. And in addition, they are responsible for paying for all costs related to the work, to their subcontractors, to their employees, and anything that is involved with taxes, royalties, license fees, warranties, any of the equipment, materials, all costs related to the project at this point are theirs to bear. And that would include the building permit and any kind of inspection fees that are associated with the project. They are expected to keep the project clean and in proper order, which often means that the project is safe to navigate about, and it is an important part of the construction process for them to keep the job clean and in an orderly fashion. They are responsible for holding harmless the architect and engineer, as well as the owner, from claims that may be caused by acts or errors on their behalf. so that they are required to hold us harmless. And they are also under the subject of some limitations within their authority on the project. But I'll go on through some more of their responsibilities before we talk about that. They're to act expeditiously throughout the project, and are to maintain payment to their subcontractors, to maintain liability insurance on the project, to maintain performance and payment bonds if they are a portion of the contract. They are subject to paying for any corrective work that is necessary that is rejected for non-compliance by the architect or engineer. They're responsible for maintaining the schedule and keeping the work on schedule and moving at a pace that is required to finish the project within the time allotted. And in that process of maintaining the work, whether the work it requires submittals or not, they're responsible for maintaining the schedule of those and being sure that those submittals move through the hands of the architect and engineer in a timely fashion so that materials can be on the site when they need to be and can be implemented or installed as necessary. And then if there is faulty work or rejected work or perhaps damaged work, they're responsible for removing, replacing, and or correcting that work at the direction of the architect or engineer. I think the next slide, Matthew, is another one of the documents from the Project Resource Manual that spells out these contractors' responsibilities. If you would like to take a look at it, it's also in the practice guide as an additional list, and it refers to items that are within AIA documents and EJCDC documents. That's a brief list of what's an expanded version in those two documents for the contractor's responsibilities. I apologize for going through those so quickly, but I wanted to get a chance to talk about expectations and also to pause for a second to have any questions as a follow-up to that. So to the contractor's role and responsibility. So Matthew, if you want to put up the next slide while we take questions, that would be okay too.
Yeah, there's just one comment here. It's actually a two-part comment that came in. It's important to potential contractors to understand, one, supplementary contracts conditions should be carefully reviewed, and two, a subcontractor is bound to the contract conditions, though they did not sign the construction agreement with the owner itself.
That's right. By extension and by contract with the primary contractor, they're obligated just the same. That's a good point. So I wanted to touch on something that is also spelled out in the practice guide, and these are expectations. I enjoy talking about the construction contract administration phase of a project as being just an expectation management phase. And all of us have expectations of the other. So here, let's take a look at what the owner expects from the architect and engineer. Well, they expect us to communicate. We're being their eyes and ears, sort of the overseer of their interests. They expect us to be knowledgeable and professional. This is a building type we understand. This is something that we know how to get done for them, and that we know that all the aspects of the project. They expect us to understand their budget and to remain on that budget, to look after their interests should modifications become necessary. And they look to us for advice to give them informed direction and accurate advice on what we do now and where we go from here. So let's take a look at the next slide. What are the contractors' expectations of us? Well, they expect us to help them in expediting the work, and this is something that I spend a lot of time talking about. I believe that projects develop a momentum, and if that is a good momentum, the projects can be successful, but we need to be a participant in feeding that project information when the project needs it, not necessarily when we have the time in our schedule to provide that information. So we need to be supportive and be an assistant to keeping the work moving as the contractor has been able to establish that work moving forward. We need to be responsive and prompt with our information. And, you know, I'm sure nobody on this call has a stack of submittals sitting in their office somewhere that's been there 30 days or 60 days, but I've heard of that happening in places. That's not being responsive, and it's certainly not helping to expedite things, and it's putting you in a very bad predicament should that project turn out to have claims. And very importantly, they expect us to be fair and impartial. We're professionals. We know what the right answers are, and there is an expectation that we act professionally and impartial. So let's take a look at the architect or engineer's expectations of the owner at the next slide there.
Jim, before we get going, we just had a couple of things that came in that I wanted to address here as we're talking about expectations of the AE. So one from Bruce, just during construction, just remember eyes and ears. As talked about previously, the ongoing problem with this is the CA versus CCA is key. Additionally, Ron wants to give a reminder of the contractor's AIA affidavits regarding departments and claims and payments is not accompanied by waivers of lien by the subs. It's a useless sworn statement because the standard AIA doc language indicates the contractor swearing is limited to the attached waivers. Those contractor affidavits are regularly expected without any sub waivers, which is useless.
I agree with that, and we often require waivers downwind from the general contractor, particularly the primary subs, and absolutely when there are copious amounts of stored materials. So that's a great point.
And then the last one we had came in here from Dean saying a key for him is the pre-construction meeting to set the project tone and expectations right away, especially as it relates to timeliness.
Absolutely, Dean. And so if Matthew, as you go to the next slide, I'll just say if we do that, if we set that tone right then, I don't find it any different than perhaps dealing with children if you have them. If you set the rules and you stick by the rules and you don't vacillate and jump around and change your mind, then they may not like what they hear, but folks pretty much get along. And I think Dean's right. If you set that tone and you hold yourself to it, and that's important, if you hold yourself to the same level of service that you're asking everyone else to provide, you show up on time because you want them to. You give them answers when they need them because you expect them from them. You set that tone at the pre-construction conference, and chances are that it will be a successful job. So what do we expect from our client, from the owner? Well, same sort of thing for the contractor. Information that's required by the contract documents. We want that to flow freely. We want to know what the chain of command is and who we're working with, who can give answers, who can make decisions, and who can't. We need people involved with the project that are decision makers and that they can promptly process the documents that they need to, whether that's pay applications or change orders, change directives, field orders, anything that involves the owner's action and knowledge. We expect prompt service from them. And we also have an expectation that they will be fair and impartial, that they're not going to be prejudiced against a contractor. This is, as Doug likes to say, we are one of the few professions in the world whose contracts are created with the anticipation of mistakes and failure. And those contracts have ways to deal with that, not if it occurs, but when it occurs. So if we act without prejudice, then certainly it's going to be a better team and a better project throughout the construction phase of the job. So Matthew, you can go to the next slide and then add anything if we need to, or I'll keep going. So what's the contractor's expectation of the owner? Money, prompt payment. A paid contractor is a happy contractor. All things considered, if things are moving like they should, making prompt payments so that the contractor can pay and perhaps receive discounts that are within material contracts that they have, critically important. Any kind of approval or decision that needs to be made, they have an expectation that will come back to them quickly. That there's financing in place, that the owner has the money to pay for the job, and that if there are owner-generated changes, that those get taken care of quickly, that they're viable, they're real, and it's not just an exercise in pricing something. Contractors have had enough opportunity to learn how to put proposals together. They don't need more of that. So they have an expectation to rely on the information that they've been given about the site or anything else is accurate. And that if there is to be some partial occupancy in the job, that they know about that and are at the table to help work that out if, in fact, as has been raised in questions here, if, in fact, it's at all possible. And that there's some reasonable end to the job, that there's reasonableness involved in determining a final completion date. Can the owner use this project for the purpose for which it was intended? And if they can, then they should be given the final completion date, and that's one of the expectations that they would have. Let's take a look at the next one, Matthew, and you interrupt me if there are any questions. What do we expect of the contractors? Well, that they're financially sound and responsible, that they've documented their procedures, they've got qualified people on the job, that they are in compliance with the contract documents, they're cooperative, fair, reasonable, and that they complete the project promptly and in accordance with the contract documents. These are not unreasonable or surprising to anyone, but are what our expectations of the contractor may be as architects and engineers. And then finally, what are the owner's expectations of the contractor? The next slide, that they too are financially sound, that they have built the project in accordance with the contract documents. Matthew, you want to go to a question here?
Yeah, we just actually had two comments that came in. One just indicating substitutions can also be investigative exercises for the architect. Additionally, actually we had another comment came in as I was talking. There's no need for the CCA to ever converse with a sub without the prime contractor present and engaged. And then lastly from Dean here, as a recovering GC and sub, I did my best to be proactive, looking beyond the present project.
There you go. As a recovering, I love that. Thank you. Well, and then finally, so the owner's expectations of the contractor, that they're sound, that they're following the contract documents, that they are paying their subcontractors promptly, that they're on schedule and going to finish the job on time, and that they are fair in pricing any kind of changes in the work. Dean talked about setting the tone at the pre-construction conference, and the first change that has to be priced as you work together as a team. This is an opportunity to establish that fair and impartial judgment for all three parties to look at this fairly as a change and to price it that way. for the architect and engineer to look at it that way, and the owner as well. So, and then also they have an expectation of accommodating in kind of partial occupancy that they would need to have happen for the benefit of their operation. So those are a quick review of expectations, and I'll just close that again by saying, and Matthew, you can go to the next slide, by saying that it's critically important to understand those expectations and managing the expectations of the group so that the project is fed with an impartial and fair hand all around the table. Do we have any other questions, Matthew? Anything to follow up on?
No, at this time everybody is quiet.
Well, I think if you look at the next slide, for the month of May, we're going to talk about pre-construction as the next subject matter, if we stay on task and on track with where we started. And I certainly hope that everyone will join us on the fourth Tuesday of May. If you have any suggestions or ideas, I love you jumping in and talking and sharing stories. So please do that. I love being interrupted, and I don't look at it that way at all. This is a discussion, so I really appreciate the participation.
All right. Well, at this time, we do not have any additional questions. So thank you again for everybody that has attended. At this time, you may disconnect and go back to your daily work schedule. And as Jim said, we look forward to seeing you next month. Thanks, everybody.